A search warrant is a court order that a magistrate or judge issues to authorize law enforcement officers to conduct a search of a person, location, or vehicle for evidence of a crime and to confiscate any evidence they find. In most countries, a search warrant cannot be issued in aid of civil process. Jurisdictions that respect the rule of law and a right to privacy constrain police powers and typically require search warrants or an equivalent procedure for searches police conducted in the course of a criminal investigation. The laws usually make an exception for hot pursuit. A police officer following a criminal who has fled the scene of a crime has the right to enter a property where the criminal has sought shelter. The necessity for a search warrant and its abilities vary from country to country. In certain authoritarian nations, police officers may be allowed to search individuals and property without having to obtain court permission or provide justification for their actions. In England and Wales, a local magistrate issues search warrants, which require that a constable provide evidence that supports the warrant application. Under Section 18, under Section 32 of PACE, a constable who arrests a person who is on their own property or has just left their premises may immediately search both the suspect and the immediate area. In Scotland, a country operating on the distinct legal system of Scots law compared to England and Wales, the restrictions governing the use and execution of search warrants are set out under Part 13 under the Criminal Procedure Act 1995. Search warrants must be signed by a sheriff after a petition from police. Gas company officials may enter a home to inspect, repair, or replace gas meters by obtaining a warrant. To get a warrant, police must present a judge with an ETO form that contains reasonable and probable grounds to believe an offense has been or is being committed and that the authorization sought will afford evidence of that offense. This hearing is ex parte, meaning only the Crown is present. This fact obliges the police to include any known facts that hurt their application. After a search, the occupants have a copy of the warrant and may get hold of the ETO through Crown disclosure if the occupant are charged. There are numerous different warrant procedures in the Criminal Code. Some have specific requirements such as being served during daytime or having a named supervising officer present in the case of a home search. If these requirements are not met by the police, the evidence found may become inadmissible against the accused at trial. Under the Fourth Amendment to the United States Constitution, most police searches require a search warrant based on probable cause. Although there are exceptions, in the absence of valid consent or an exception to the warrant requirement, whether for purposes of effecting a search or an arrest, police entry in an individual's home always requires a warrant. The probable cause standard for obtaining a search warrant is lower than the quantum of proof required for a later conviction. Proof beyond a reasonable doubt. Under the Fourth Amendment, search warrants must be reasonable and specific. This means that a search warrant must reasonably identify the items to be searched for and the place where law enforcement officials are authorized to search for those items unless an exception to the warrant requirement applies. The search of other buildings or areas of a building, persons or vehicles, or the search for additional items that do not reasonably fall under the original warrant, will normally require additional search warrants. To obtain a search warrant, an officer must prove to a magistrate or judge that probable cause exists for the proposed search. Based upon direct information or other reliable information, an application for a search warrant will often rely upon hearsay information, such as information obtained from a confidential informant. As long as probable cause exists based on the totality of the circumstances, police can seize both property and persons under a search warrant. The rationale is that evidence police collect without a search warrant may not be sufficient to convict, but may be sufficient to suggest that a warrant would allow police to find enough evidence to convict. The issue of federal warrants is determined under Title 18 of the United States Code. The law has been restated and extended under Rule 41 of the Federal Rules of Criminal Procedure. Federal search warrants may be prepared on Form I-93, search and seizure warrant. Although the laws are broadly similar, each state has its own laws and rules of procedure governing the issuance of warrants. Search warrants are normally available to the public. On the other hand, they may be sealed if they contain sensitive information. Certain searches do not require a search warrant. For example, in a plain view case, the officer is legitimately on the premise